Good morning, everyone, and welcome to the third day of opening statements at the Undercover Policing Inquiry. My name is Neil Fernandez, and I am the hearings manager. This is day 3 of the opening statements in Tranche 1, Phase 2, and this phase will conclude on the 14th of May. I will now hand over to our chairman, Sir John Mitting, to formally start proceedings. Chairman.
Thank you. Today, as yesterday, I'm going to begin by reading a short statement. I do so at the request of Celia Stubbs. On this day, in 1979, Blair Peach was struck on the head during a demonstration at Southall, causing his death. Blair Peach was a teacher and a committed campaigner against racism. His partner, Celia Stubbs, is a core participant in this inquiry, and her opening statement, which set out the circumstances of his death, was read to the inquiry yesterday. There will now be a minute's silence to commemorate Blair Peach. Thank you. Ms. Williams.
Good morning, sir.
Good morning.
This statement is made on behalf of families who became aware that the identities of their deceased loved ones were appropriated for the purposes of constructing the covert identities of undercover police officers. Specifically, Frank Bennett and Honor Robson, the bereaved brother and sister of Michael Hartley, who died on the 4th of August 1968 at 18 years of age. Faith Mason, the bereaved mother of Neil Robert Martin, who died on the 15th of October 1969 at 6 years of age. Lisa Crossland and Mark Crossland, the bereaved stepmother and brother of Kevin John Crossland, who died on the 1st of September 1966 at 5 years of age. Mr., Mrs. and Miss Lewis, father, mother and sister of Anthony Lewis, who died on 31st July 1968 at 7 years of age. Barbara Shaw, the bereaved mother of Rod Richardson, who died on 7th September 1973 when he was just 2 days old. Each of our clients experienced the death of a child, a life event amongst the most difficult that it is possible to suffer. More recently, the families have also suffered the horror of learning that their loved ones' identities were used by undercover officers precisely because of their bereavement, because their son or daughter lost their life when they were a child. This phase of the inquiry is a particularly important one from our clients' perspectives, as it was during the years covered by this phase of evidence that undercover officers started to use deceased children's identities, and it rapidly became the Special Demonstration Squad's, the SDS's, standard practice. Our clients seek answers from this phase of the inquiry to the most fundamental issues regarding this callous misuse of their loved ones' identities. How on earth did this abhorrent practice come to be adopted? How did it come to be embedded in SDS procedures? Were there alternatives that could and should have been adopted instead? Did anyone consider the impact upon the bereaved families of this practice? And at what level within the Metropolitan Police Service, who are referred to as the MPS, was it authorised or condoned? Our clients have searched for answers to these questions for too many years. They hope they will not have to wait much longer. Barbara Shaw, the mother of Rod Richardson, for example, has been trying to uncover the truth since 2013. She is now very frail and her health is failing. She is distressed to contemplate that she will not live long enough to find out these answers. The families we represent engage in this inquiry because they want to know whether this abuse of their memories of their loved ones was necessary, whether it served any legitimate purpose, and if not, why it was permitted to become such an embedded practice. On the material now disclosed for this Tranche 1 Phase 2 hearing, we believe that the conclusion inevitably must be that there was no clear rationale, no sufficient justification, and no necessity for this repulsive practice. In the earlier Tranche 1 Phase 1, the families learnt that between 1968 and 1972, none of the SDS officers, who I will refer to as the UCOs, who we heard evidence about, relied upon the identity of a deceased child, and none suffered compromise of their cover identity in consequence. Their fictitious covert identities were protected, it would appear, by common sense, by the maintenance of distance from their subjects and keeping a low profile. During this period, the SDS deployed UCOs without any need to appropriate the identity of dead children. Furthermore, the evidential picture that emerged from this first phase of the inquiry did not suggest that there were any pressing operational imperatives that either were prompting or were sufficient to prompt the abandonment of the practice of officers using fictitious identities for their legends. I turn to the early Phase 2 period, prior to the use of deceased children's identities. We have searched in vain for evidence in the thousands of pages of the Tranche 1 Phase 2 bundle that would justify the dramatic change of approach that took place in or about 1974. We do not believe it exists. Several of the officers whose evidence will be heard or summarised in Phase 2 were deployed before 1974, with one exception involving Officer HN298's own decision to use a real person's identity. It seems that use of fictitious identities continued until some new SDS officers were deployed in 1974. For example, HN45, cover name Dave Robertson, HN299, also known as HN342, cover name Dave Hughes, HN301, cover name Bob Stubbs, and HN347, cover name Alex Sloan, were deployed before 1974 and all used fictitious identities. None of these officers have suggested in their accounts that using a fictitious identity caused a specific concern amongst them in terms of maintaining their cover. And furthermore, none of their experiences suggest that using a fictitious name was a cause of or heightened the risk of exposure. One of these officers, HN45, did have his undercover identity compromised in December 1973, but this had nothing to do with using a fake name. HN45's own account is that a member of the public Ethel met him when he was still a uniformed officer and greeted his arrival undercover at a meeting at the London School of Economics with, quote, "Here is Scotland Yard, come to take us away," close quote. He was withdrawn from the field immediately. Diane Langford in her statement recalls aspects of the incident differently, but in any event, it is plain from both accounts that the officer's fictitious covert identity played no part in his compromise. The compromise was caused by visual recognition by someone who had met this officer in the past. We are only aware of 2 other incidents where Phase 2 UCOs faced a challenge to their cover identities. HN 347, who infiltrated the Irish National Liberation Solidarity Front, which I will refer to as the INLSF, was withdrawn from his deployment in 1971. There is nothing to suggest that his use of a fictitious identity played a part in those events, and it will be appreciated that the practice of using fictitious identities continued for around another 3 years after that. This officer, HN 347, describes the INLSF as being, quote, very nervous, unquote, regarding infiltration by undercover officers, and how he was followed and tracked to his cover flat and confronted by 2 members of the group stating that he was a pig. His deployment was ended as a precaution. It is hard to see how those matters would have played out any differently if that undercover officer had been using a deceased child's identity. Secondly, HN 298, who, as I have just mentioned, did use a real person's identity, seemingly of his own volition, describes being challenged as a spy and responding by assaulting his accuser. As he was not withdrawn from his deployment, presumably the risk of compromise cannot have been considered all that significant. The lack of justification for the dramatic change in policy is underscored by the contents of the SDS's own annual reports, documents prepared each year by the officer in charge of the unit for consideration by the senior echelons of the MPS and the Home Secretary. The 1972 annual report, written on 14th of February 1973 by HN 294, the detective inspector who was then head of the SDS, confirmed at paragraph 17, quote, one of the main advantages of a field officer assuming a fictitious name, using a cover address and employment and radically altering his appearance is that, unlike an informant, he can resume his proper identity and appearance at any time and immediately be lost to the extremists. The 1973 annual report from HN 294, now a chief inspector, was written on 6th of March 1974, the very year in which it seems the new practice commenced. But far from identifying a new or increasing threat to the unmasking of his undercover officers, he described, quote, the avoidance in nearly 6 years' existence of the irretrievable exposure of any SDS officer, close quote. And the point still holds good if the evidence should show that the practice was introduced in the previous year, 1973, since the 1972 annual report, written in early 1973, contained the almost identical observation that, quote, since the formation of the squad, no officer has been irretrievably exposed or identified. So it seems that after 6 years of operation, the SDS had relied upon a perfectly serviceable means of acquiring fictitious covert identities. What then provoked the change? We have also re-examined the SDS's Tradecraft Manual, which we referred to in our opening statement for Phase 1. This was the document, it will be recalled, that referred so dismissively to the bereaved families and their deceased loved ones in offensively flippant terms. For example, the officer's task was characterised as, quote, finding a suitable ex-person, usually a deceased child, close quote. And officers were advised to find a death that was, quote, natural or otherwise unspectacular. Checking whether the deceased child had living relatives was referred to as identifying their, quote, respiratory status, unquote. The manual notes that by 1994 there was growing unease amongst SDS managers about the obvious risks inherent in adopting a provably false identity, since hostile inquiry, as it was described, would reveal that the person the undercover officer purported to be was in fact dead. The text also recognises, significantly, that these were not new concerns. To the contrary, there had been, quote, many earlier fears that using deceased children's identities were, quote, indeed unsafe, close quote. I now turn to the start of the practice of using deceased children's identities. The material that has now been made available indicates that from at least 1974 onwards, UCOs used the identity of a deceased child and were either specifically instructed to do so or were given to understand that this was the expected practice. For example, HN 200, who used the cover name Roger Harris, HN 353, Gary Roberts, and HN 351, Jeff Slater, were all deployed as part of the SDS in 1974. HN 200 says in his statement that he was, quote, told that the normal way of choosing a cover name was to go to Somerset House and find someone who had died. In the same paragraph, he says, quote, he, quote, did query whether it was necessary to do this, but it was explained that this was the usual process, close quote. He describes someone from the SDS back office coming with him to Somerset House to, quote, show me the ropes, as it was a big undertaking, close quote. Officer HN 353 says that someone in the SDS told him how to choose a cover name by attending Somerset House and finding a person who had died who would have been of a similar age to him if still alive. HN 351 describes it as follows, that it was, quote, the convention at the time that a deceased child's identity would be used, close quote. But he goes on to say that he does not recall the rationale for this being discussed. Phase 2 officers who were later deployed to the SDS have given similar descriptions of being told to use a deceased child's identity in the creation of their legend. For example, HN 304, who used the cover name Graham Coates, who joined the SDS in 1975. HN 354, Vince Miller, who joined in 1976. HN 126, Paul Gray, who joined in 1977. And HN 96, Michael James, and HN 106, Barry Tompkins, who both joined in 1978. However, the disclosed documents offer no explanation for why the use of fictitious identities was abandoned. We do not know who made the decision, when it was made, or why it was made. Mr. Barr, Queen's Counsel, indicated in his opening statement to the inquiry on Wednesday that the inquiry has not found any contemporaneous written instruction or guidance documents amongst the mountains of materials that have been considered that addresses or explains the introduction of this practice. In short, nothing has been provided that could justify the damage that the change of practice has caused to real, bereaved, vulnerable human beings. Nothing that could justify the huge risks of avoidable harm to policing itself. The inference that we reasonably draw is that the relevant decision makers did not contemplate the possibility that they would ever be asked to answer questions in public about this practice. The very fact of this inquiry's investigation serves a vital public function in communicating that these senior police officers are not above the law. The actions of those senior decision makers will come into focus in Tranche 1, Phase 3, and the evidence to be heard in the coming weeks will be of great significance to the questions that will arise for them. In order to try and understand the introduction of the practice, we look back at the justifications that were advanced in the Phase 1 opening statements by the designated lawyers, group officers, and the MPS. In summary, it was said there was an essential operational imperative for undercover officers to rely upon real identities. The designated lawyers' opening statement said the justification for relying on the identity of real people was to place officers in a position to support their false identity by way of a birth certificate that could be produced as proof if that they were who they claimed to be if they were challenged, and that the equivalent could not be done if a fictitious identity was adopted, as there would not be a birth certificate in a publicly accessible register of births, which were contained within bound volumes. Their opening statement continued that reliance on fictitious cover identities quote, was adopted to begin with, but reviewed and abandoned after a number of undercover officers were compromised or outed, close quote. However, I have already described incidents where officers' cover identity was compromised. Strikingly, none of those incidents suggested or warranted the conclusion that the use of a deceased child's identity would have made any material difference. The designated lawyer's Phase 1 opening statement also said, quote, some officers were uncomfortable with the practice, some regarded as necessary tradecraft, and all proceeded on the basis that there was no alternative and the families of the deceased children in question would never know. The Phase 1 opening statement on behalf of the MPS also relied upon alleged necessity, saying that evidence would be given in Tranche 1 and 2, quote, as to why the practice was considered necessary at the time to support the work of undercover officers. Well, we have yet to see that evidence. The MPS's opening statement for this phase of the inquiry does not provide anything more concrete, and indeed appears to acknowledge that in relation to the introduction of the practice, the inquiry will be testing, quote, the extent to which it was operationally necessary. We also note that in the Phase 1 opening statement provided by the National Crime Agency, who I will refer to as the NCA, the following was said, quote, the NCA has never had a policy that involved encouraging undercover officers to use the identities of deceased children when creating their legend identities, nor is the NCA aware of any such policy being in place within the regional crime squads, the national crime squads, or serious organised crime agency. We suggest it is material that the regional crime squads operated from the 1960s until they were replaced by the National Crime Squad in 1998. The regional crime squads contained dedicated undercover units that legitimately be described as specialists in undercover policing. They operated prior to the digitisation of birth records without appropriating the identity of deceased children. The MPS suggested in its opening statement for this phase that the change in practice coincided with, quote, infiltration of more security-conscious organisations, which they said, quote, brought a need to ensure that the identities used by the undercover officers could withstand scrutiny. However, if this practice was introduced because UCOs were outed and or because of the threat of this occurring was thought to have significantly increased, we would have expected to see a commensurate increase around this time in other SDS precautions aimed at shoring up the credibility of undercover officers' legends, at preventing their exposure by those who were being spied on. But again, we have looked for this evidence in vain. Turning firstly to the officers who were deployed undercover in 1974, Officer HN 200 says in his statement that he did, quote, not create a particularly detailed background persona. He goes on to say he did not supply an autobiography or go through a process of eradicating inconsistencies within it with his superiors. He said he received no written guidance on creating his legend and, quote, it was largely left to me. Both HN 353 and HN 351 also said they were not provided with any other written guidance. A similar impression emerges from the undercover officers who were deployed over the next few years. For example, HN 126 says of his cover identity in his witness statement, quote, it is possible that it was not very detailed. I do not think anyone ever really tested it. HN 354 says there was no formal training as to the creation of a legend and no manual, and he comments, quote, I have been asked whether my undercover persona was sufficiently developed to include a cover background. I simply made my legend up as I went along. And he goes on to say that his legend was not tested by managers. So on the face of it, this apparent casualness over the creation of undercover officers' legends does not sit well with the proposition that fears of their exposure had escalated and had become so great by 1974 onwards that they had to adopt this extreme tactic of misappropriating the identity of a dead child. We note, of course, that the technique of using a dead person's identity came to public prominence via Frederick Forsyth's The Day of the Jackal. The novel was published in 1971 and the film was released in 1973. The timing is interesting. Could it be that a work of fiction rather than operational necessity inspired the introduction of this repellent tactic? Once introduced, the practice of undercover officers employing the identities of deceased children appears to have lasted around 20 years, albeit not consistently in the later years. We hope the inquiry will look carefully at the justification for it, not only at its inception, but as time progressed. Strikingly, there was a demonstration of its risks and limitations shortly after it was introduced. As Mr. Barr, Queen's Counsel, briefly mentioned on Wednesday, the now deceased HN 297 Detective Constable Richard Clark, who was known in his cover name as Rick Gibson, was deployed in early 1975 and was withdrawn in September 1976, where members of Big Flame, a group he was spying on, confronted him with official copies that they were able to obtain of both the birth and the death certificates in his cover name. Richard Chessum's witness statement indicates that suspicions surrounding Rick Gibson's identity first emerged because he appeared to lack the understanding of the political and historical background and events that would be expected of an activist in their circles. The reference years later in the Tradecraft manual to an SDS officer being, quote, confronted with his own death certificate appears to be a reference to the compromise of DC Clark's covert identity as Rick Gibson. And it seems clear that the officer constructed his covert identity from the personal details of a deceased child, consistent with the SDS practice of the time. And that it was the inability of the child's death certificate which clinched the suspicions of those who confronted him. Accordingly, far from confirming that use of a deceased child's identity provided a secure means of maintaining cover, because a real birth certificate existed to be found if a suspicious person went looking for it, this episode, in fact, vividly illustrated the dangers of relying upon a real person's identity, because the death certificate, as well as the birth certificate, was there to be found. As Mr. Barr noted, Detective Constable Clark was one of the first officers to use a deceased child's identity, and the technique proved not robust enough to protect his cover. In operational terms, it was a failure. Deceased children's identities were not a prophylactic against exposure, and managers knew it. There may be a further dimension to DC Clark's outing. On the account of an officer whose testimony has been gisted by the inquiry, Clark told him that he had a couple of sexual relationships in his cover identity, which led to his identity being compromised. Richard Chessum recalls that this officer had sexual contact with at least 4 female activists, including one or more members of Big Flame, the group that became suspicious and started to inquire into his background. The same undercover officer also had casual sexual relationships with both Mary and her flatmate, who he met through Goldsmith College and the Troops Out movement. Mary describes how they both found his behaviour oddly detached. For example, he never stayed the entire night. But they didn't consider the possibility that he was an undercover officer until they were informed of Big Flame's discovery. What does seem clear, though, is that DC Clark was willing to behave in a way that put exposure of his true identity at considerable risk, and in a manner that may very well have drawn suspicions upon himself. His behaviour was certainly the antithesis of the conduct we heard described in Phase 1, where officers spoke of the importance of keeping distance and maintaining a low profile as essential elements to retaining cover. The circumstances of Clark's exposure and withdrawal from the field prompted the officer who held overall responsibility for the SDS at the time, Chief Superintendent Bicknell, to send a memo to his superior officer informing him of the compromise and offering reassurance that both he and Superintendent Neal were, quote, keeping a very close eye on it. The compromise of D.C. Clarke was considered to give rise to, quote, extreme safety concerns. It is therefore extraordinary that the practice of reliance upon dead children's identities was not immediately abandoned after these events in 1976. It is equally extraordinary that they did not lead to a disciplinary investigation regarding D.C. Clarke's gross misconduct while undercover. A proper review of all these matters in 1976 would likely have identified that use of deceased children's identities, particularly when allied to outrageous conduct in undercover roles, ran significant risks of compromise and could not be justified. Moreover, such a review would likely have brought focus to bear on the importance of an undercover officer's own conduct and their maintenance of high standards of professionalism in the securing of their own safety. In reality, the use of fictitious identities and maintenance of strict professional standards, including keeping a distance from the subject of the surveillance, afforded far better cover than that provided by officers preying on the biographical details of dead children who had suffered tragic early deaths and then failing to adhere to professional standards once they were deployed. There are other instances of undercover officers who used a deceased child's identity attracting suspicion. HM126, Paul Gray, came under suspicion, but it was not considered a sufficient threat to require his removal from the field. So this is a further example where an identity based upon a real person offered no more protection than a covert identity based upon a fiction. HN304, who used the cover name Graham Coates, had his cover identity compromised because he gave his real name when stopped by police. But obviously that episode provides no support at all for the proposition that use of a deceased child's identity afforded greater protection. As far as we can see, there was no justification for adopting the practice of reliance upon dead children's identities, and no justification for continuing with it after the dangers associated with it were exposed by the events in 1976. Not only did the SDS fail to revert to the practice of relying upon fictitious identities, but they did not take steps to direct and ensure that officers did not compromise their covers or put them in jeopardy by engaging in conduct antithetical to their policing responsibilities. The available material indicates that SDS managers failed to oversee that officers prepared assiduously for deployment and once in the field, maintained distance and avoided unnecessary intrusion. All of this speaks to a lack of professionalism and a unit that was operating far beyond the boundaries of proper policing. By way of further example, from the date of his deployment, 1974, it is highly likely that undercover officer HN300, who used the cover name Jim Pickford, was employing a deceased child's identity. As Ms. Kaufman, Queen's Counsel, explains yesterday, this officer embarked on a sexual relationship with one of the women he was spying on and subsequently had a child with her. So not only did the reliance upon deceased children's identities continue and indeed become the embedded practice of the SDS for a further 2 decades, but the gross misconduct of officers under cloak of those identities continued, indeed escalated, as Ms. Kaufman described yesterday. I turn to the moral dimension. On the face of it, remarkably few SDS officers appear to have experienced qualms of conscience about appropriating a deceased child's identity. We have seen nothing to suggest that this immensely important aspect was taken into account by their superiors, even after it must have become known that officers were conducting deceptive sexual relationships under these stolen cover identities and, as I will come on to describe, committing crimes. One of the officers' accounts, where we only have the short gist provided by the inquiry, says he considered, quote, the moral implications of doing so at the time, but considered it was the right thing to do as the only way to effectively protect his safety. We've already addressed the latter proposition. It is unclear whether there was any wider discussion of the moral implications amongst this seemingly tight-knit group of officers and the superiors who they met with and spoke to very regularly. There plainly should have been. One officer, HN80, says in his witness statement that it distressed him to use the details from a deceased child's birth certificate. Quote, "And I knew that it would necessarily cause distress to the family if it was discovered." He goes on to describe identifying a death certificate for a Paul Clark, but making clear to his managers he wanted to use a different first name, Colin, and his own date of birth. However, his account suggests that his request was not fully accommodated, as some of Paul Clark's details were used in relation to the driving licence and passport that he was provided with in the Colin Clark cover name. His account raises a number of issues which our clients hope the inquiry will explore in this and in phase 3. As his managers were made aware of this officer's concern about causing unnecessary grief to a bereaved family, did this give them any pause for thought? Even if, shockingly, they had not considered it before, did they then think about the moral dimension at this stage? If not, why not? Were his concerns discussed amongst the other undercover officers? Did any of the officers who adopted a deceased child's identity believe they had a choice over the matter, or were they given to understand that they must follow an instruction to that effect? We also note that HN80 was deployed undercover for almost 5 years with the SDS. So in his case, it seems that despite his less than wholehearted adoption of the prevailing policy of using a deceased child's identity, that was not regarded as compromising his cover. On a related topic, our clients are keen to understand the extent to which the details from the deceased children's lives were adopted and the extent to which officers visited the area in which the child lived. Mr. Barr described the accounts of 2 of the phase 2 officers in this respect in his opening on Wednesday. We note that HN96, who used the cover name Michael James, says that he was instructed to visit Blackpool, the birthplace of the deceased child, and that he received assistance from the local special branch in making inquiries about the family's address. Given the terms in which this is described, it seems hard to credit that this instruction was a one-off. Why weren't HN96's contemporaries given similar instructions? Was there anything unique about this case? Or are other UCOs being less than forthcoming with the inquiry about the degree of intrusion they were responsible for? We note that Mr. Barr has confirmed this issue will be explored with the phase 2 witnesses. As I have already touched on, our clients have an additional concern arising from the use of deceased children's identities, which they also hope the inquiry will look at carefully. And this is the extent to which officers committed criminal offences and were arrested, prosecuted, and were still convicted in those names. Although officers' use of the names of our family's loved ones will not arise until later tranches of evidence, our clients want to understand more generally the extent to which this shocking state of affairs occurred and the extent to which, if at all, it gave managers pause for thought about the wisdom or the morality of using real identities belonging to real people. Undercover officer HN13 is deceased, but his widow confirms he used the surname of a deceased child from Wiltshire. This officer was arrested, charged, and convicted of public order offences in the name of the deceased child he took. And as has been described in earlier opening statements, HN298, who was using the identity of a real person without, it seems, checking first whether they were alive or dead, was arrested, charged, tried, and convicted in his cover name for offences of obstructing a police officer and willfully obstructing the highway. Other officers may have escaped arrest and prosecution, but they were willing, it seems, to run that risk by committing offences when they were using a deceased child's identity. For example, HN297 is described as participating in fly posting in his local area. Surely the fact that undercover officers could face prosecution and conviction in their adopted identities provided further compelling reason for SDS superiors to be extremely cautious about using the identities of real people? Was any regard paid to the consequential and wholly unjustified besmirching of their good names? Was any regard paid to the likely impact on bereaved families of learning that their loved ones' reputations have been tarnished in this way? Were any steps taken to protect the real, living, as it turned out in the case of Michael Peter Scott, whose details HN 298 so casually misappropriated? Mr. Barr said on Wednesday that the inquiry has not been able to establish whether these convictions were ever attributed to the real Michael Scott, but we hope investigations in relation to this important matter will continue. From all we have read, the callous interference with bereaved families that we have described was in every sense consistent with the motivations, culture, and broader practices of the SDS, a unit that had been permitted to operate without legitimacy or accountability over several years by now. Whilst from 1974, prospective UCOs were told to take the steps necessary to acquire elements of the identities of the deceased children by their superiors, there is no indication in the material that we have seen of actual supervision of the officers with regard to their use and misuse of the data they accessed. Not a hint of any consideration by senior officers as to the proportionality of their actions, nor to the potential consequences for the bereaved family should they become aware of what was happening. Not a sign of any appreciation that this could never be characterised as an action taken on the public's behalf in anticipation of public consent, and no review of necessity, efficacy, or risk. On the contrary, this abhorrent, grossly abusive technique simply became the embedded cultural practice of the SDS, where it sat alongside other abhorrent behaviours, all of which manifested in the context of a unit that lacked legitimacy, accountability, or effective supervision. In preparing for this phase of the inquiry, our ability to probe the adoption of the practice of appropriating deceased children's identities and to examine the extent to which the previous approach afforded UCO sufficient protection has been hampered by the restrictive approach taken to disclosure. The MPS has argued this inquiry, Sorry, I'm going to start that sentence again. The MPS has argued that should this inquiry require disclosure of information about its undercover policing techniques and methodologies, real and tangible harm would be caused to policing. This has led to what our clients consider to be extensive and potentially excessive redactions of information regarding the practices surrounding the creation of fictitious identities prior to 1974 and the practices surrounding reliance on the identities of deceased children thereafter. Our clients struggle to understand how any harm to policing can be derived from disclosure of information regarding obsolete or discredited and abandoned policing techniques. It is, from our clients' perspective, the abhorrent practice of using the identities of their loved ones that has caused the harm to policing. Policing by consent has been the philosophy of British policing for almost 2 centuries. The 9 principles of policing, issued to every police officer from 1829, explicitly required police officers to, quote, recognise always that the power of the police to fulfil their functions and duties is dependent on public approval of their actions and behaviour and on their ability to secure and maintain public respect. Also, quote, to maintain at all times a relationship with the public that gives reality to the historic tradition that the police are the public and the public are the police. The conduct of the SDS has been the absolute antithesis of policing by consent. We have therefore invited the inquiry legal team to review whether each and every redaction sought by the MPS is in fact sufficiently justified. And we do hope that greater openness may be possible, particularly where the redactions conceal information regarding the discredited and abandoned technique, which is at the very centre of this aspect of the inquiry's investigations, or where the concealment only concerns obsolete practices. We invite this review because of the absolute importance to our clients of the inquiry's investigations being open and transparent, and then being able to participate as fully as possible. The evidence as it emerges is that the SDS operated with impunity and with great confidence that the units and its managers would not be called upon to account for its actions. This inquiry's great burden, of course, is to ensure that this expectation on the part of former SDS officers does not spread its cloak over the means by which it may detect and expose police wrongdoing. A more open approach to information concerning these practices will, we suggest, assist the inquiry in discharging its functions. Paragraph 23 of the 1973 annual report pointed out that the risk of compromise could never be extinguished and that individual officers bore a, quote, great weight of responsibility to maintain their cover through careful preparation of their, quote, political backgrounds, cover addresses and employments. And it went on to say that anticipating suspicion so that periods when it was necessary to, quote, live the life full-time might be kept comparatively short. This common sense guidance sits in stark contrast with the evidence the inquiry will hear from and about undercover officers in this phase in terms of their actual conduct on the ground. The inquiry will hear from officers who took scant interest in their own backstories, whose preparation and attitudes were casual, who recorded little and who recalled less, from officers who left the expected professional standards far behind when they deployed into the field. It appears that the security services were available and did assist with the provision of fictitious cover identities and materials to underpin and make credible those identities on a few occasions. But no answers emerged from the Phase 2 documents bundle as to why the SDS took what appears to have been its own path. As we have shown, as late as 1972 and 1973, the leadership of the SDS was expressing confidence in the unit's reliance upon fictitious identities. The reason for the unit's switch to using identities of deceased children at this stage remains an unexplained mystery. The evidence to be heard in this phase of the inquiry is of grave importance to the bereaved families. We believe that it will establish that reliance upon the identity of deceased children became an adopted and embedded practice in the SDS without any clear rationale. Our clients seek full scrutiny, effective lesson learning, and the implementation of tangible protections against future abuses. Thank you very much, sir.
Thank you, Ms. Williams. We will now have a 10-minute break until 11 o'clock when we will hear from Mr. Scobie.
Thank you, sir.
Thank you.
We will now take a 10-minute break. The time is now 10:50 a.m., so we shall reconvene at 11 a.m. Thank you. Welcome back, everyone. I shall now hand over to the Chairman to continue proceedings. Chairman.
Thank you. Mr. Scobie.
Thank you, sir. I appear along with Piers Marquis of Doughty Street Chambers and Paul Heron of the Public Interest Law Centre. And this is an opening statement on behalf of Richard Chessum and Mary. We represent 4 core participants who are directly affected by undercover officers, whose evidence is to be heard in this phase. Richard Chessum and Mary were spied upon by Detective Constable Richard Clark. And we are using his real name because it is one of the few that the inquiry has disclosed. Every other officer that we refer to, and there are many, are referred to by their cover name. We also represent Lindsay German and John Rees. They were spied upon, at the very least, by Phil Cooper and Colin Clark. The evidence of other officers impacts directly on the Socialist Workers' Party, the organisation in which they held central committee roles. We were directed to provide this written opening statement by the 14th of April 2021. That direction was made on the basis that the inquiry would disclose the evidence of these officers by the 4th of March 2021. That was not done. The material in respect of Clark was not provided until the 1st of April 2021. At the time of writing, the inquiry has still not served a witness statement from Colin Clark. It has not served a single page of disclosure in respect of Phil Cooper. We've asked that these officers be put back to the next phase to give those who were spied upon a chance to contribute. The inquiry has refused, thus denying these people the opportunity to provide an opening statement before the evidence is given. The inquiry has denied itself the chance of looking at that evidence from the perspective of those that were spied upon, rather than those doing the spying. It is obvious to anyone, and plainly to this inquiry, that late or non-disclosure inevitably restricts the ability of non-state core participants to review the material, investigate the detail, and ultimately put forward their side of the story. Is this a deliberate policy? Despite the limitations that have been forced on us, we will show that the Special Demonstration Squad went far beyond its original remit, that DC Clark manipulated the democratic processes of an organization to place himself in a high position of responsibility. From there, he was able to destabilize and attempt to decapitate the organization. We will show that to achieve that high position, he used and exploited the trust of law-abiding citizens, including 4 women, victims of his manipulative sexual relationships. We will show that in those positions of power, those in positions of power in the Metropolitan Police were fully aware of his tactics. We will show that Clark's deployment served to direct the undercover officers that followed to take up organizational roles, which then became the norm. We will show that ultimately authority for all of this came from the highest level of government. Prime ministers were aware of the activity and remit of the Special Demonstration Squad. We will also draw attention to the evidence showing widespread blacklisting of individuals because of their political views and invite the inquiry to properly scrutinise this evidence and deliver a degree of belated justice to the victims. We will also demonstrate that the inquiry has the evidence to effectively challenge these officers when they try to justify their behaviour. We urge the inquiry to take the perspective and experience of the ordinary people that were spied on and directly make that challenge. It has a duty to do so. DC Richard Clarke. In December 1974, Richard, Chessum and Mary were students at Goldsmiths College. Mary was studying to become a teacher. Richard was finishing off a sociology degree. Both were members of the college's Socialist Society, intelligent people committed to helping others. Mary was 27 years old. She had come to the UK having grown up in South Africa. She had witnessed the state violence and injustice of the apartheid regime. She campaigned on issues of anti-racism, women's liberation, civil liberties, and free speech. She was an elected student union officer, devoting much of her free time to campaigning and helping others. Richard Chessum was 32. He'd been a Methodist lay preacher working full-time at the South London Mission. He was involved in the Fellowship of Reconciliation, an international movement committed to active non-violence to change the world for the better. He'd worked as a political officer for his local Labour Party and been involved in the campaign for nuclear disarmament. He demonstrated against the war in Vietnam and against apartheid. He joined the Anti-Internment League and organised the lobbying of MPs in the aftermath of the shooting of unarmed civilians by the British Army on Bloody Sunday. At around the same time, in December 1974, DC Richard Leighton Clarke was deployed into Goldsmiths College by the Special Demonstration Squad. He was 29, married, with children. A police officer for 5 years, he stole the identity of a deceased child, Richard Gibson, from the records at Somerset House. He enrolled at the college on a Portuguese language course. Clarke's target was the Troops Out movement, an interesting target from the perspective of this inquiry, because it did not fit with the stated aims of the Special Demonstration Squad. The movement posed no public order risk at all. Its aims were publicly stated and straightforward. 1, self-determination for the people of Ireland, and 2, the withdrawal of British troops from Northern Ireland. Their methods were lobbying members of Parliament, drafting alternative legislation, and raising awareness with the occasional low-key demonstration, talks, and film screenings. The Troops Out movement had already been infiltrated as recently as 1974 by HN 298 Mike Scott, who concluded that, quote, it had no subversive objectives, and as far as I'm aware, did not employ or approve the use of violence to achieve its objectives, close quotes. Scott was right. There was no history of any public order issue related to the movement, either before Clarke's employment or in the many years that followed. So, what was the justification? DC Clark is dead. Therefore, we don't have a witness statement from him or the opportunity to ask him questions. However, we have had sight of disclosed reports that he wrote. Reading those alongside the evidence of Richard Chessum and Mary, we can gain significant insight into how he worked. Step 1, identifying a target organization. First, his remit was meticulously planned. Shortly before he was deployed, he wrote to the National Office of the Troops Out movement. He told them that he was a student at Goldsmiths and asked about any local Southeast London branch that he could join. He already knew that there wasn't one. Richard Chessum had previously been involved with the Anti-Internment League, and so was known to some in the National Office of the Troops Out movement. He had not become involved because he was studying hard and had recently been ill. He had not joined and had no plans to do so. Nonetheless, the National Office contacted Richard Chessum and a meeting was arranged between him and Clark. By February 1975, using the Social Society as a tool, Clark had succeeded in creating an entirely new branch of the Troops Out movement. There were 5 founder members of that branch: Mary, Richard Chessum, Richard Chessum's partner, another student, and of course, DC Richard Clark himself. Clark had completed step 1. He was in the Troops Out movement. But rather than infiltrating a branch, he had actively established one. He generated something to spy on. He encouraged and organized demonstrations, such as the picketing of the local Woolwich barracks and the homes of local MPs. This created the potential for public order problems that the Special Demonstration Squad supposedly existed to prevent. He created targets to spy on. Neither Mary, Richard Chessum, nor his partner had special branch files in their names until they became involved with Clark. Richard Chessum had come to Special Branch's attention before because he had merely written a letter to the Black Dwarf publication, but there was no file on him. In all 3 of their cases, their Special Branch files were tagged with 1975 as the year of their creation, after they had met Clark. What was the result of Clark's work? Richard Chessum and Mary had their personal lives reported and monitored to an extent that was both sinister and ridiculous. Details of their private lives passed up the chain of command and along to MI5, their physical appearances, commentary on their body size, addresses, personal relationships, place of work, hairstyles, immigration applications, health issues, what theatre productions they went to, where they were going on holiday, not only to and who with, right down to the brand of cigarette they smoked. There was no reason for any of this. None of these people posed a threat to anyone. They were targeted first because of their politics. Secondly, they were useful, and Clark used them. Step 2, developing an identity and building trust. Clarke aimed to get himself into a position of trust and responsibility. He managed to do exactly that. What were his difficulties? He had no back history. He had just appeared. So before he could engineer himself into a key position, he needed to establish a background for himself and a place in the social network of political activists. That was step two. He did that by exploitation. Mary is unequivocal. Clarke used sexual advances on activists as part of a way of ingratiating his way into the group as a whole and building a backstory. He certainly did that with her. Clarke initiated a sexual relationship with Mary, having been invited by her into her home. It was not just Mary. In total, he had sexual relationships with 4 activists that we know of. A pattern emerges from his reports. We can see that Clarke exploited each one of these women to assist him with his infiltration of the troops out movement, and on at least one occasion to gain a tactical advantage. The other 3 women were a friend of Mary's, who, for the sake of anonymity, we'll simply call Mary's flatmate, and 2 activists from the organization Big Flame. That was an additional target of Clarke's in the latter part of his deployment. We will address these relationships as we go through the timeline of DC Clarke's deployment. The sexual relationship with Mary and the establishment of a close friendship with Richard Chessum were part of a tactical strategy and helped him achieve step 2. Step 3, taking positions and moving up the hierarchy of a target organization. As one of the founder members of the South East London branch of the Troops Out movement, Clarke used it to gain access to the national movement. This was Clarke's step 3. It was to prove quite difficult, but he managed it with an astonishing level of ruthlessness. By the 18th of March, 1975, Clarke had got himself elected as the secretary, the top position in the branch. He and Richard Chessum were then elected as voting delegates to the Troops Out Movement Liaison Committee Conference. That move gave Clarke access to the movement at a national level and exposure to the leadership. With the added credential of being a branch secretary, it ensured that he would be accompanied there by Richard Chessum, a man with a proven track record of genuine commitment. Clarke's cultivated friendship with Richard Chessum gave him credibility. On both the 2nd and the 7th of April, 1975, Clarke got himself elected as a delegate to the London Coordinating Committee of the movement and the All-London meeting. On the last of these occasions, he had chaired the branch meeting which had taken place at Richard Chessum's home. He was becoming known at a national level. At a branch meeting on the 21st of April, 1975, he pointedly took an opportunity to, in his own words, and I quote, severely criticize, close quote, another section of the movement. It was a move that appeared to ensure that he was elected as the branch's delegate to the National Coordinating Committee of the Troops Out movement. The 16th of June, 1975 was a key date. There was political division within the Troops Out movement. That was replicated in the South East London branch. the group Workers' Fight had mobilized their members to the branch in an attempt, as far as Richard Chessum was concerned, to take control of it. There was significant political infighting at the meeting. Despite this, Clark was once again elected to be a delegate for the next London Coordinating Committee. But this time, he was elected along with a member of Workers' Fight. Where previously his position as a founder member had guaranteed his delegate roles, the influx of Workers' Fight members could make things problematic for him. If they succeeded in completely taking over the branch, then Clark would no longer be able to attend the London and national meetings. He would fail at step 3. On the 23rd of June 1975, again, Clark and the member of Workers' Fight were elected, this time as delegates to the National Coordinating Committee. 4 days later, Clark attended a private meeting organised by the head of the National Troops Out movement, Jerry Lawless. There were only 10 people in attendance. There were people that were seen as key to supporting Lawless's position in the national movement against Workers' Fight and the Revolutionary Communist Group to take control of the organisation as a whole. Clark was one of the 10. He had used his attendances at the London and National Committee meetings to get close to Lawless and was now seen as a key supporter. In his report, Clark noted that the group, Big Flame, had also formed, and I quote, an uneasy alliance, close quotes, with Lawless. On the 7th of July, 1975, at a branch meeting, there was, quote, an unprecedented, close quote, turnout with a number of additional attendees from Workers' Fight and the Revolutionary Communist Group. One of those additional attendees was Mary's flatmate, who was a member of Workers' Fight. She had attended various Troops Out movement pickets over the preceding weeks, but this was her first attendance at a meeting. The chances of Clark continuing to be elected as a branch delegate to the London and national meetings were rapidly reducing as it was. 2 months later, on the 16th of September 1975, there was another meeting of the South East London branch. This one was overwhelmingly attended by members of the Revolutionary Communist Group and Workers' Fight. There was an election for delegates to attend the London Coordinating Committee meeting 3 days later. This particular committee meeting was going to be an important one because it would select delegates that could stand for national positions. The 2 South East London branch delegates would be potential candidates for those positions. One member of Workers' Fight was elected as a delegate. For the remaining position, Clark stood against Richard Chessum, and he was elected by an additional 2 votes. This is significant, as we believe that one of those votes was from Mary's flatmate, a member of Workers' Fight, who conveniently Clark had been having a sexual relationship with. The next day, at a Big Flame meeting, Richard Chessum lamented the takeover of the South East London branch by members of Workers' Fight. Clark was present. Sure enough, on the 19th of September 1975, at the London Coordinating Committee that Clark was a delegate to, he was elected to the Organising Committee for London. It was a national position. He had now passed beyond branch level politics. Clark had first stood against his friend, Richard Chessum, and in doing so, an undercover officer had deprived the movement of a national officer who genuinely had the interests and aims of the movement at heart. Clarke had replaced a decent man, Richard Chessum, with himself, an undercover police officer. To get there, he had secured the support, we believe, of at least one member of Workers' Fight, a female activist who he just happened to have been sleeping with. By the 27th of September 1975, the Workers' Fight takeover of the branch was complete, with all 5 of the delegates elected to the Troop Site Movement Conference, National Conference, being from that group, including Mary's friend. It no longer mattered to Clarke because he'd already passed beyond the branch. He would be going to the National Conference by reason of his new national officer role. On the 13th of October 1975, he resigned the position of branch secretary. He no longer needed it and made what he himself called in his report to his police superiors, and I quote, a scathing attack, close quotes, on revolutionary communist group and Workers' Fight. Richard Chessum remembers that resignation differently. He recalls Clarke simply saying a few words in a laid back and matter-of-fact announcement. But that apparently, and I quote, principled resignation, close quotes, would demonstrate to the national leadership of the Troop Site movement, particularly Jerry Lawless, that he was on their side, that he was part of the, and I quote, clique run by Jerry Lawless, close quotes. In his new role on the organising committee of the Troop Site movement, Clarke quickly became the London organiser, nominated for the position by Jerry Lawless himself. Shortly afterwards, he was again nominated by Lawless, this time for a position on the National Secretariat. He obtained this position and was then one of only 7 people in charge of the whole movement. He continued his relationship with Richard Chessum, primarily because he had friends in Big Flame. That organisation had been notoriously difficult for the SDS to infiltrate, but Clarke was targeting it. He continued to attend meetings at Richard Chessum's home and reported on him. He recorded that Richard Chessum had started a new job at the London Electricity Board. This information was passed to MI5. Mary and her flatmate largely disappeared from Clarke's reporting now that they had served their purpose. Clarke busied himself with activities in the Troop Site movement. He became an organiser of the national rally, where he failed to secure the attendance of any of the proposed headline acts. They included John Lennon, who also had a special branch file open in his name, and Peter O'Toole, who may or may not have had a file held on him. Clarke also pushed for the removal of the Troop Site movement press officer from the Secretariat, and then secured himself a position on the press committee. He arranged speakers for the movement's public meetings. He even helped to arrange what was called, quote, a strong contingent of stewards, close quote, to prevent attacks from the National Front. That was a legitimate protective measure. Yet, we expect to see those from Youth Against Racism in Europe, the Anti-Nazi League, and the Socialist Workers' Party criticised for the same thing in a later part of the inquiry. By March 1976, when Jerry Lawless had to stand down for paternity leave, Clarke took his position as convener of the Secretariat. He was then in charge of the whole movement for several months. What did Clarke do in this leading position? We do know that he proposed and persuaded delegates to vote for postponing a long-planned Troop Site movement trade union delegation to Ireland. A press statement was then prepared explaining that decision, presumably by Clarke, in his additional position on the Troops Out Movement Press Committee. We know that he used his position as national convener, quote, to severely criticize, close quotes, another individual member whose name has been redacted. And he was also involved in the censuring of Sean Matt Gamner, a very prominent member of the Troops Out movement. In the course of his stewardship, at least one prominent organization withdrew its affiliation. There was also serious dissent with the international Marxist group over decisions taken in respect of the trade union delegation to Northern Ireland. By the time Jerry Lawless returned 4 months later, 2 members of the Secretariat had resigned. Remember, this was a serving Metropolitan Police officer working undercover, making day-to-day decisions for a campaigning organization. Clarke had also entirely repositioned his loyalties. Having been an ardent supporter of Lawless and using his support to maneuver himself into the Secretariat, he now turned against him. In reports to his superior officers, Clarke referred to, and I quote, typical Lawless tantrums, close quotes. And on the 25th of July, 1976, he took the highly unusual and hugely risky step of holding a meeting at his own police cover flat. The meeting with Big Flame members was, and I quote, attempting to offer some form of resistance to the leadership, i.e. Lawless's supporters, within the Troops Out movement, close quotes. They were discussing an internal coup, decapitating the Troops Out movement of its long-time head. On the 2nd of September 1976, a further meeting with Big Flame took the coup project further. Clarke noted in his report at the time, and I quote, independent elements within the Troops Out movement have, over recent months, become increasingly frustrated at carrying out the doctrine of the, quote, lawless clique. Big Flame members in the Troops Out movement have been instrumental in bringing together some of the more influential members of the organization in the hope of formulating a common policy with which to fight the leadership at the next National Delegate Conference, due to take place in late November. Clarke described, I close quotes, Clarke described the meeting as, quote, a significant beginning. The major aim of those represented would have to be the defeat of the present leadership and the replacement of them by independent members, close quotes. The new leadership was proposed at that meeting. It included 4 redacted names and Clarke himself. What were his motives? Was it to destabilize and decapitate the Troops Out movement? Was he trying to ingratiate himself with Big Flame? Perhaps his plotting was a means of doing that. He had spent the summer trying very hard to infiltrate them, chairing meetings, listing himself as a member in reports. Clarke also embarked on sexual relationships with 2 female members of the Big Flame. For him, sexual relationships were a tried and tested tactic of getting exactly where he wanted to go. He had used Mary to give himself a background and authority, her flatmate to ensure a vote to get it up to national level of the Troops Out movement, and 2 Big Flame activists to try to cement his position in that group, in the process firming up support for his coup. However, with Big Flame, Clarke had overreached himself. We do not know exactly what his mistake was. Was it holding a meeting in his unlived-in undercover flat, or was it, as another officer suggested, that he gave different accounts of his background to Big Flame activists he was sleeping with? Perhaps it was that his Machiavellian approach was just too obviously dishonest. Perhaps, as Richard Chessum suspects, Big Flame were canny enough to recognize that Clark had no political background knowledge. But whatever it was, members of Big Flame also went to Somerset House and they found Rick Gibson's birth certificate. And then they found his death certificate. They confronted Clark with both. Richard Chessum tells of how he heard about this confrontation from his friends in Big Flame, how he went white and nearly started to cry. His ambitious plot to unseat Jerry Lawless was over. So what was the fallout? Clark took flight and disappeared from the political scene altogether. Richard Chessum later saw a dossier that Big Flame had prepared that included a letter from Clark written to one of the female activists saying that he, and I quote, that he had to go away, close quotes. Clark's exposure is significant for one other clear reason. When he walked out, there was no threat of physical violence towards him and no attempt at retribution. A standout theme across the groups that were infiltrated over the decades is that none of them were interested in violence unless they had to defend themselves. If there was ever a reason and an opportunity for violence against an undercover officer, this was it. It was not how these groups who stood for principles conducted themselves. This example highlights the SDS attempts to justify their infiltrations and their applications to have their identities hidden. They look desperately inadequate. Were the commanders and commissioners of the MPS, the Metropolitan Police Service, aware of what was going on? Clark's taking of high office was known to his superiors, all the way up to the commander of the Metropolitan Police Service. The early principle of Special Demonstration Squad, and I quote, that members of the squad should be told in no uncertain terms that they must not take office in a group, chair meetings, draft leaflets, speak in public, or initiate activity, close quotes. That principle had been completely abandoned. Equally, the fact that he engaged in sexual relationships with activists was no secret either. 2 officers to date have been honest enough to disclose that they knew of DC Clark's behavior. One of those officers has gone further and admitted that sexual relationships were talked about at the weekly officer meetings and that his supervising officers would have been aware because they were present. He recalls 2 separate occasions when Clark's sexual relationships were raised at those meetings. He thinks that other officers and managers were present on both occasions. It was inevitable that they would talk about it. Police officers in an almost exclusively male environment, relaxed, with their guards down amongst their own in the late 1970s, when institutionalized sexism was endemic. To suggest otherwise will be to turn a blind eye to reality. It is refreshing to see that at least Officer Coates told the truth. But how many will pretend they did not hear, or were out of the office on those days, or simply when presented with simple questions, get angry and indignant that they're being asked at all? Counsel to the inquiry has an abundance of material to test these officers thoroughly. Should officers lie on oath, as sadly is anticipated, one wonders how the inquiry will deal with such dishonesty. Senior officers knew about Clark taking prominent roles and interfering in the democratic process of the Troops Out movement. They also knew he was sexually abusing female activists. Despite this, he left the force with a special medal, a detective inspector's pension, and his conduct certified as, quote, exemplary, unquote. There is only one explanation for this. His conduct was deemed acceptable. It continued for years. The Category H women are testament to the decades of sexual misconduct at the hands of these officers. Following Clark, the taking of positions of responsibility and trust in these organizations was commonplace. Many of the officers we will hear from say that they cannot remember being elected to the position of trust, that they were plainly elected to, or they will say they did not really have a choice but to be elected. It just happened. Or they say that the role was not really a position of trust at all. The institutionalized dishonesty creeps into every aspect of their evidence. Political policing and positions of trust. And here are a number of examples of officers obtaining such senior positions. Mike James, HN 96, started his deployment in the Socialist Workers' Party, where he was elected to a position on the Hackney District Committee. After 2 years, he moved on into the Troops Out movement, where Clark had been 4 years before. James is an interesting officer because he's one of two that give different accounts of the position they reached. In his impact statement, a document arguing the case for his continued anonymity, he described himself as the national secretary of the Troops Out movement, i.e., the top role. Once his anonymity was secure, he shifted and tried to play down and minimize the importance of his position. He was the national membership and affiliation secretary of the Troops Out movement for a good 18 months. He's one of the officers that seems to suggest that he just happened to fall into these roles rather than actively pursuing them. But he was on the top level of the organization, the National Steering Committee, which he occasionally chaired. He was one of 9 people with a direct influence over the direction of the movement, and he controlled the lifeblood of any organization, its membership. He was also on a number of additional committees, specifically tasked with organizing demonstration. But it was not just Clark or James. Once the dam had cracked, there was a flood of undercover police officers taking roles in the organizations they infiltrated. In some cases, officers took national leading roles. What resulted from this was not just information, but also the opportunity to have a say in the direction of the organization, and ultimately to seek to derail that organization. HN 348, Sandra Davis, has already said that she did not remember being elected to the executive committee of the Women's Liberation Front. She didn't remember voting to oust the founding leader and create a completely new group, the Revolutionary Women's Union. HN 155, Phil Cooper, and HN 80, Colin Clark, were so close to the Central Committee of the Socialist Workers' Party that they were able to access the headquarters of the organization. Phil Cooper was so involved that, in his own words, he got to sleep, and I quote, with groupies. We don't yet know exactly how prominent they became within the organization. because 6 weeks after the deadline for disclosure, the inquiry has still not provided us with their documentation. HN 200, Roger Harris, does not remember being the contacts organizer for the Twickenham branch of the International Socialists, a branch which was then involved in a destabilizing breakaway from the main group to form the Workers' League. HN 300, Jim Pickford, chaired meetings, attended national conferences as a delegate, wrote articles, ran classes, argued against individuals being granted membership. He was granted position of branch treasurer. He booked halls for meetings. HN 13, Barry Loader, was described by his own superior officer in an internal memo, and I quote, as an active and trusted member of the Communist Party of England, Marxist-Leninist, who is to attend the national conference. HN 353, Gary Roberts, claims he was never in a position of responsibility for the International Marxist Group. However, his cover was as a full-time degree course student at Thames Polytechnic, with his fees paid for by the Metropolitan Police. Whilst in that cover, he became the vice president of the Students' Union. He was a delegate at the National Union of Students conferences and attended the International Marxist Group caucuses at those conferences, involved in the selection of, and I quote, of so-called revolutionary candidates. He does not remember being trusted enough by the International Marxist Group to be asked to be a delegate on overseas trips, including to Romania, which was then in the Eastern Bloc, France and Belgium. And I quote, on behalf of the International Marxist Group leadership, close quotes. He says he must just have been the driver. He has no recollection of being on any of the many committees that his reports say he was clearly on. HN 354, Vince Miller, was elected as a district treasurer and on the social committee of the Outer East London district branch of the Socialist Workers' Party. He resigned from his position to mark, and I quote, the disorder and ineffectiveness, close quotes, within the branch. Resignation combined with strong criticism is deliberately destabilizing to the organization. HN 296, Jeff Wallace, was elected as the flame organizer for the Socialist Workers' Party, Hammersmith and Kensington branch, and a Socialist Workers' Party organizer. He attended the London Regional Delegates Conference and was one of the three organizers of the Anti-Nazi League Carnival. We do not know what he would have to say about any of this because there's no statement from him. Not because of death or ill health, but because the inquiry has not got hold of him because he's abroad. In the age of telecommunications, it seems strange they have not been able to track him down in an inquiry of this importance. HN 351, Jeff Slater, cannot remember being the Socialist Worker newspaper organizer for the North London district of the International Socialists. HN 356, Bill Biggs was the branch treasurer of South East London Socialist Workers' Party, chaired meetings and became the Socialist Worker Organisation for the branch. At an aggregate meeting for the South East District, he voted as a delegate on a proposal to condemn a decision taken by the Central Committee. He spoke as a guest speaker at another branch's meeting and was the branch treasurer for the Socialist Workers' Party Brixton branch. HN 126, Paul Gray, became Socialist Worker paper organizer for Cricklewood branch. And then for the whole of the Northwest District, he was on the district committee, which had control over all three of the branches that the district covered. He was re-elected in 1979 and 1980. He chaired meetings. He was on the organising committee of the West Hampstead Anti-Nazi League and the Northwest London Anti-Nazi League Coordinating Committee. He was also a delegate to the Camden Against Racism Committee. He says he doesn't remember any of the last roles. He says his role as socialist worker paper organizer was collecting newspapers and dropping them off. Basically, he was just a delivery boy with a van. That is a major difference from the story he gave when he was trying to secure his anonymity. Like Mike James above, Paul Gray's risk assessment plays up his role, and in his case states that he was a key organizer in the Grunwick dispute, a strike with national coverage and importance at the time. With his anonymity secure, he is rowed back from that now. So what is the truth? Socialist Workers' Party and political policing. It is clear, in respect of the troop site movement, both Clark and James reached the very top. None of the officers in the Socialist Workers' Party have been very helpful about what their positions of trust and responsibility involved. Of course, at the time they made their statements, there were no core participants or witnesses from the Socialist Workers' Party in this inquiry. They could safely describe their roles as they wanted, with no risk of their credibility being undermined. That position changed on the 2nd of March 2021, when 3 former Central Committee members of the Socialist Workers' Party secured core participant status. Between them, Lindsay German, John Rees, Chris Nynham had 4 decades of experience on the Central Committee from 1979 to 2009. Because they are latecomers and the disclosure from the inquiry has been woefully late, they will not be able to be as involved as they need to be until phase 3. However, they can assist at this stage in respect of the structure of the party and the roles that the infiltrating officers obtained. The last 4 officers that we have mentioned, Wallace, Slater, Biggs, and Gray, all had positions as socialist worker organisers. Critically, they were organisers, but they were more than that. The Socialist Worker was the organisation's newspaper. It was the scaffolding of the whole organisation. The newspaper was a major source of income for the organisation and key to recruiting new members. It was the political mouthpiece of the organisation through which they communicated their politics with the public. The sale of the paper was also a regular flashpoint for public disorder, with sellers regularly attacked by members of the National Front. The Socialist Worker newspaper was understood by these officers to be the central component of the organisation as a whole. The role of organising that paper was absolutely pivotal. At branch level, the organiser was second only to the branch secretary. At district level, the role was even more critical. The district newspaper organiser, along with the district secretary, would be the link between the Central Committee and the members. These 2 roles were responsible for setting the political line within their district every single week. They decided what the paper sellers in their district would speak to the public about. The Socialist Worker newspaper organisers had responsibility, trust, and authority. They had a direct role in shaping the progress of the party. These officers knew that. Paul Gray even reported to his superiors that he'd been spoken to in public by the National Socialist Worker Organisation. He was told that every, and I quote, every organiser should know exactly where each paper was sold every week, and that spot checks should be made on members to see that paper sales were being carried out. Gray was given a list of selling techniques and told to visit all of the branch offices regularly. And I quote, constantly remind them that to sell the paper is the most important duty of an SWP member, close quotes. At that time, the state of the Socialist Workers' Party nationally was at an all-time low. Membership and paper sales were down. The Northwest London district, where Gray was second in command, was characterised by, and I quote, apathy. A year later, having done the job for 2 years, he was replaced. This is one clear example of an officer taking a role of responsibility and trust and willfully undermining the organisation by not doing the job properly. 3 things stand out. First, from Clark onwards, every officer in this phase took a position of trust. The only exception was HN 304 Graham Coates. He was unable to take a position in any hierarchy simply because he infiltrated anarchist groups, and they did not have hierarchies. In different ways, these officers all impacted on the progress or direction of the organizations they infiltrated, from taking a role that deprived a genuine member of the chance to do a committed job to destabilizing and even decapitating the organizations. There is a distinct lack of honesty about the role they played or the extent to which their superiors were aware. Blacklisting, a direct effect of political policing. The question of blacklisting, we've raised this in Richard Chessum's statement and our first opening statement. To date, there have been no answers. We just have the bare fact of the correlation between Clark opening the file and passing Richard Chessum's details to MI5 and his subsequent inability to secure any significant job. Despite his education, decency, intelligence, lack of criminality, the door was closed on teaching, lecturing, and research jobs, and even sorting mail. What we have seen in this new phase of disclosure are countless examples of civilians having the details of their employment passed up the chain to MI5. Each time their political affiliation is included next to the note of their employment. Union memberships are also regularly noted. People targeted are those in the public sector or public service jobs, such as working for a local council, NHS doctors, hospital workers, senior priest, post office workers, a job applicant with HM Customs and Excise, a social worker, and a probation officer, and numerous teachers. Reports on a traffic warden and a public office clerk even include details of their sexuality. Many of the officers say that these were just little details to, quote, update files, close quote. Occasionally, there will be an officer who gives a more realistic answer, equating the undercover officer interest in employment with preventing problems in workplaces. Problems like the democratic right to strike, people campaigning for fair pay, health and safety conditions. Both Special Branch and MI5 were specifically asking for employment details on individuals. The SDS obliged. we know that at least one member of the Socialist Workers' Party was sacked from a government body simply because of her political opinion. Both her name and the nature of the government body have been redacted by the inquiry. We also know that both MI5 and Special Branch were confident that her sacking would not be traced back to the undercover officer that had caused it. Attempts by officers to justify their deployment, with information being freely and regularly passed the Metropolitan Police's SDS squad to MI5, this brings us to our next point in this opening statement, the question of justification. There was no public order rationale for the infiltration of the troop site movement. There was no rationale for the spying and reporting on Richard Chessum and Mary. There have been attempts by officers to justify infiltrations of campaigning and political organizations. Many of those justifications relate to the Socialist Workers' Party. Because of time limitations, we'll have to address most of the detail at the beginning of phase 3. However, some aspects have to be raised now so that the inquiry is then in mind for the future. As far as Graham Coates was concerned, the Socialist Workers' Party, and I quote, were very dull, close quotes. These deployments were not designed for officers' entertainment. It is assumed he means dull from a policing perspective. Mike James said that the Socialist Workers' Party were not engaging in subversive activities, that most members were, quote, entirely peaceful, close quotes, and there were some elements that looked, quote, to engage in violence at events, close quotes. But he accepted that these were involved in a breakaway group. The Socialist Workers' Party did not promote violence. The party had a rigorous policy of expelling members who engaged in squadist confrontational violence. Mike James knew the breakaway group Red Action had actually been expelled because he had reported on it. Generally, we accept these particular assertions of these two officers. But where officers go beyond that, for example, as we set out below, we dispute their evidence. We hope that it will be appropriately challenged by counsel to the inquiry. In respect of one particular officer, we do make some observations. Paul Gray has made a number of remarks about the Socialist Workers' Party, in particular about levels of subversion and violence that are plainly not true. First, of course, they are contradicted by a number of his fellow officers. Secondly, they are entirely unsupported by evidence. He gives a grossly exaggerated account of the demonstration in Grosvenor Square in 1968, when he was a uniformed officer. He then asserts that he experienced the same level of violence in the course of his undercover deployment. He is clearly lying. In the hundreds of pages of his reports, there is no reference to him witnessing any violence. Paul Gray claims that his lack of reported violence is because the SDS only provided advanced intelligence. He says they did not provide reports on violence or disorder they had witnessed, only on violence or disorder they were expecting. That is a very convenient explanation for a total lack of such evidence. It is simply a lie. It is clear that SDS officers did give retrospective intelligence about public order events. We can see that from officers who did witness such events. It is also clear that despite his denials, Paul Gray did give retrospective intelligence. From a policing perspective, it's common sense. It would be valuable intelligence if targets were actually involved in violence or disorder. The difficulty that Paul Gray faces is that his retrospective reports show no violence or disorder at all. One report shows a single arrest for nothing more than obstructing a police officer. There are no reports of violence witnessed, nor of any expected violence either. His allegations are post-event attempts at justification. Gray, and I quote, is extremely angry, close quotes. There's been disclosure of how the SDS operated, and that this has led to this inquiry. He says that his time undercover had no impact whatsoever on his, quote, welfare, but that answering questions for this inquiry is impacting on his welfare. That is because he now has to justify the fact that, in reality, he busied himself with pointless and personally intrusive reporting. In one report on a member of the Socialist Workers' Party, he spent 2 whole paragraphs detailing private sexual behavior. Another is solely dedicated to reporting on a member who was employed as a tax officer, and as he notes, was, and I quote, was believed to be a homosexual, close quotes. For someone so interested on reporting the sexual relationships of others, he is surprisingly silent on the sexual relationships that his fellow officers had with activists. He was in the Special Demonstration Squad with Vince Miller, Mike Hartley, Alan Bond, and Phil Cooper. He emphatically denies any knowledge of their sexual activity and maintains that the conduct of his contemporaries was, and I quote, exemplary. One of the features of this phase is the number of reports on school children. Gray reported on more children than any other officer, recording the minutiae of their lives and sending them onto MI5. Almost all of those reports have photographs of the children attached. He reports on a 15-year-old schoolgirl, 15 and 13-year-old schoolgirls, and their parents. In 2 separate reports, he describes the photographed schoolboys, quote, as effeminate, close quotes. In one report, he comments on how much time a schoolboy spends at his girlfriend's house. The closest Gray has ever come to reporting on violence is his note that a schoolboy had a fight with his brother. These children were either the children of Socialist Workers' Party members or children who were engaged enough with their society to be part of the school kids against the Nazis. And to justify this, he reverts to type and suggests that these children were either subversive or violent. On behalf of Lindsay German and John Rees, who were well aware of the actual activities of school kids against the Nazis, we dispute that entirely. In the course of Paul Gray's deployment, Column 88 were threatening to burn down the homes of SWP members. The National Front were attacking Bengalis in Brick Lane, smashing up reggae record shops and graffitiing mosques. They were burning down Indian restaurants and murdering young men like Altab Ali and Ishaq Ali in Whitechapel and Hackney. Whilst they were doing that, Gray and his so-called exemplary SDS colleagues were writing about what they refer to, and I quote, as Jewish finance of the Anti-Nazi League. I quote, a negress activist, an activist with a, and I quote, large Jewish nose, and I quote, coloured hooligans. Such language and views that are beneath contempt. Instead of investigating the racist firebombing that killed 13 young black people in New Cross, the SDS were reporting on school children and providing MI5 with copies of Socialist Workers' Party babysitting rotas. The question of government and cabinet knowledge. Several of the Phase 2 officers refer to visits to the SDS safe house by the Commissioner of the Met Police. One refers to congratulatory messages straight from 10 Downing Street. Another, who himself went on to become Detective Chief Inspector, was told, and I quote, that the continuation of the unit was one of the first decisions that a new Home Secretary had to make. That anecdotal evidence is supported by the 1976 authorization for the Special Demonstration Squad's continued existence. It was signed off by Robert Armstrong. Later, Baron Armstrong of Ilminster. He was Cabinet Secretary and head of the Home Civil Service. Between 1970 and 1975, he had been the principal private secretary to two prime ministers, Ted Heath and Harold Wilson. It's difficult to imagine a more highly placed civil servant. In a statement provided to Phase 2 of the inquiry by witness Z, the security services themselves confirmed, and I quote, the pressure to investigate these organizations often came from the Prime Minister and Whitehall, close quote. So there can be no doubt now that the existence and functioning of the SDS was known of and authorized at the very top. It is interesting that every annual application for funding refers to the officers fully recognizing, and I quote, the political sensitivity of the unit's existence, accompanied by assurances that all necessary steps had been taken to ensure security. Authorization is only ever granted, and I quote, in view of the assurances given about security, close quote. In other words, as long as you can promise us we will not get caught, you can carry on. This fixation on security is important. First, successive governments were well aware of the need to keep the extent to which they were spying on law-abiding civilians absolutely secret. Secondly, governments were repeatedly told that a significant part of the, and I quote, security, close quote, effort involved the creation of watertight cover stories and false identities. From at least 1975, every officer is clear that the use of a dead child's identity was the only authorized way to create a viable backstory. There is no realistic way that government could not have known that this method had been comprehensively adopted. The conclusion of that aspect of this inquiry must be that the government endorsed the use of deceased children's identities and the Metropolitan used them specifically to ensure that government was protected. That is a damning enough conclusion in itself. But the inevitable consequence from that is critical. The Metropolitan Police Service were protecting the government from what they referred to in the 1977 annual report as, and I quote, embarrassment. There is nothing embarrassing for a government about spying to prevent crime, but the destabilizing of democratic movements, the wholesale and widespread intrusion on law-abiding civilians, and their exploitation for political advantage. That is worth keeping secret. This inquiry has been set a challenge to get to the truth. This means asking difficult questions again and again to uncover the truth. Ordinary people have been involved in campaigns for a better society, for social equality, anti-racism, anti-fascism, against apartheid, and for trade union rights. The best of reasons and the best of traditions. We hope the inquiry is ready, willing, and equipped to meet that challenge. The inquiry must be fearless and unflinching in the pursuit of the truth. The people of this country expect nothing less.
Thank you, Mr. Scobie. We will now have a break of a quarter of an hour, which by my timing takes us until just after 1/2 the hour. And we will hear from Mr. Menon.
We will now take a 15-minute break. The time is now 12:20, so we shall reconvene at 12:35.
But your timing is much better today.
Hi, Rajiv. Sorry.
Hello.
All right, just going to pop you into your room. Rob's waiting.
How's my Wi-Fi connection? Is it strong enough?
Yeah, it looks fine.
Okay, good. Now, because I'm at the Old Bailey in a private room, I just wasn't sure how good it was.
All right. No, it looks fine. Yeah.
Thank you.
There you go. Just accept that invite, please.
Welcome back, everyone. I shall now hand over to the chairman to continue proceedings. Chairman.
Thank you very much. Mr. Menon.
Thank you, sir. Can I just check that you can see and hear me?
I can indeed.
Thank you. Can I also apologize in advance if, whilst I'm speaking, there's the odd tannoy message that can be heard in the background? I'm in a room in court, and there's nothing I can do to disengage the tannoy system, unfortunately.
Please don't worry yourself, but for the fact that I can mute myself, you might hear some agricultural noises off stage.
Thank you, sir. Good afternoon. From the outset of the undercover policing inquiry, the non-state core participants have been raising concerns about the state's obsession with secrecy and anonymity, about the importance of openness and transparency, about the inability of the non-state core participants to participate effectively, about the inquiry's approach to restriction orders, witness selection, and documentary redaction, and the absence of any meaningful right of appeal against its decisions about these matters, and about late disclosure that does not afford nearly enough time to prepare properly for opening statements and evidential hearings. For the avoidance of doubt, we recognize the enormity of the many tasks facing the inquiry team, the difficulties caused by the pandemic, and the undoubted obstacles being placed in the inquiry team's path by others. We note, for example, the recent challenge of the designated lawyer officers group in the administrative court by way of judicial review to an unknown decision by the inquiry chairman. The non-state core participants remain completely in the dark as to the nature of this challenge or the legal or factual basis for the court's decision in allowing the challenge, as the court's two-paragraph open judgment is devoid of detail. This is yet another stark example of how so much of the business of what is supposed to be a public inquiry happens behind closed doors, with the non-state core participants having no seat at the table. We reiterate what many of the non-state core participants keep repeating, namely that an inquiry into undercover policing without the effective participation of those targeted, spied on, and infiltrated by the secret state is an inquiry not worth having. Nevertheless, we remain ready and willing to try and assist as best we can by raising what we believe are the fundamental issues that arise from the Tranche 1 Phase 2 disclosure, and proposing what we believe are the necessary questions that should be asked of those witnesses who are due to give evidence. Last November, we made an opening statement on behalf of numerous individual and organizational non-state core participants. During the Tranche 1 Phase 1 evidential hearings that followed, the inquiry heard evidence from two non-state core participants, both of whom we represent. Tariq Ali was the only non-state core participant to give oral evidence. Ernie Tate could not attend for reasons of ill health, but his statement was read into evidence. Sadly, Ernie, who was one of the founding members of the Vietnam Solidarity Campaign in 1966, passed away in February. There are many moving tributes to him on the internet. Just to give one example, the Canadian historian Brian Palmer said that, and I quote, "Ernie Tate was a literate and cultured man, able to reflect engagingly on art and literature, film and music. He could build a cottage and renovate a house, organize a demonstration, engage a crowd, and convince others of the need to use their particular talents to fight for a better world." We remain in contact with Ernie's widow, Jess McKenzie, who hopes that this inquiry will do justice to Ernie's memory. In Tranche 1, Phase 2 of the inquiry, I, together with Russell Fraser of Counsel and Richard Parry of Saunders Solicitors, represent Piers Corbyn. Now 74 years old, his recent notoriety as a speaker at anti-lockdown protests up and down the country shows he has not given up his activism and still retains the energy of his youth. He was one of the original applicants for core participant status and was designated by the inquiry as long ago as October 2015. He will be giving evidence on the 28th of April, some 5.5 years after having been granted core participant status. Before we address you, sir, on the secret state's particular interest in Piers Corbyn, we would like to make 7 general points about the material disclosed in the Tranche 1 Phase 2 hearing bundle and the inquiry's approach to witnesses, redactions, and disclosure. Point number 1. What literally screams out from the pages of the current hearing bundle is the fact that the primary focus of the Special Demonstration Squad, hereafter referred to as SDS, was never the protection of parliamentary democracy or the prevention of public disorder. Whatever the undercover officers on the ground who were deployed by the SDS may have been told by their superior officers and may have genuinely believed, the primary focus of the SDS was to spy on individuals and organizations because of their ideas and their politics. It was their ideas and their politics that were deemed, quote unquote, subversive to the British state and a threat to the British establishment. It was their ideas and their politics that led to political support and financial backing for the SDS being authorized by the very highest echelons of both the police and the government. The limited public disorder during street protests, for example, during the odd skirmish with the National Front, that some of the undercover officers who were spying on socialists and anarchists describe in their witness statements, was largely minor and low level. It certainly did not justify the spying on an industrial scale that was unleashed on the British public in the 1970s, or the consequent cost to the public purse. Furthermore, it is fanciful to suggest that any of the relatively small political groups that were infiltrated by SDS officers, directly or indirectly, posed a threat to parliamentary democracy. We are still waiting for MI5's annual threat assessments to be made public. These could make interesting reading. Just to give 2 examples of SDS intelligence reports that demonstrate the real priorities we submit of Special Branch and MI5. A 21-page report on an international Marxist group and Spartacus League conference in May 1972, and a 55-page report on the National IMG conference in August 1976. We provided the references in our written opening statement. These reports detail the different currents and tendencies within the IMG, summarize the many debates that took place at the conferences, and provide the names and registry file references of those in attendance. What the reports singularly lack is anything touching upon the protection of parliamentary democracy or the prevention of public disorder. In short, as we said in November in our opening statement then, the SDS was engaged in secret political policing and pure intelligence gathering against the left, at times Orwellian, at times more Monty Python. Insofar as it is suggested that the police, particularly in the 1970s and 1980s, were politically neutral, that is palpable nonsense. What minimal SDS spying there may have been against fascist groups was very much an afterthought, despite right-wing extremism and widespread racist violence being serious social problems that plagued our communities throughout the 1970s and 1980s, in the wake of Enoch Powell's infamous Rivers of Blood speech in 1968. This is not the propagation of a partisan anti-police narrative. This is fact. We should never lose sight of the fact that the British secret state's addiction to harvesting and retaining massive amounts of personal information on its targets was on par with anything practiced by more notorious secret states internationally. This is reflected in the witness statements of many SDS officers, in which they admit gathering as much information as possible, however personal, however trivial, because it was for others higher up the chain of command to decide what was relevant. Point number 2. The most significant document in the Tranche 1 Phase 2 hearing bundle, we believe, is the statement of Witness Z on behalf of the Security Service MI5 that confirms what we asserted in our opening statement last November, namely that the SDS has always, from the very beginning, been subordinate to MI5. This corporate statement merits careful reading and thorough scrutiny, even if at times it paints a distorted picture. A glaring example of this is the assertion that Special Branch's role is limited to issues of law and order, whereas Special Branch, whatever its guidelines might say, has in fact, throughout its history, been primarily focused on the policing of ideas. Astonishingly, Witness Z is not being called to give evidence. We cannot understand why. What a wasted opportunity. There is so much that Witness Z could have been asked about the respective roles of Special Branch and MI5 within the apparatus of the secret state, about the minutiae of their relationship, about MI5's 1972 definition of subversion as, and I quote, activities threatening the safety or well-being of the state and intended to undermine or overthrow parliamentary democracy by political, industrial, or violent means, about how most, if not all, of those spied on by the SDS could not possibly be described as subversive according to that definition, about how a group who wants a road closed as a play street for kids, or a group who wants to keep public transport cheap, or a group who wants to stop abortion rights being undermined, could present a public order threat, even obliquely, let alone a threat to parliamentary democracy. About how the secret state itself undermines the very fabric of our democratic institutions. Point number 3, sir. Although there are, on our count, 18 SDS officers who were deployed during this relevant period, whose cover names have been disclosed and who are alive, the inquiry is only calling 8 of them to give evidence. That is said to be sufficient for the purpose of discharging the inquiry's terms of reference, an exhaustive investigation being neither necessary nor proportionate for that purpose. Of the remaining 10 officers, the evidence of 7 will be summarized. The attendance of all 10 has been excused either at your direction, sir, and or for reasons of ill health, and or because the witnesses live outside the jurisdiction and are therefore not compellable. The 1970s was a critical period in the history of the SDS. The inquiry we submit would be assisted by as much evidence as possible from as many SDS officers as possible. We do not agree with respect that it would be unnecessary or disproportionate to adduce a greater breadth of evidence. As was apparent during Tranche 1, Phase 1, witnesses, when questioned by counsel about matters that took place decades ago, sometimes remember unexpected details that do not feature in their witness statements. In the circumstances, it's unfortunate that the inquiry is not hearing from more SDS officers during this tranche and phase. Point number 4, we are dismayed by the inquiry's change of approach to fully anonymous SDS officers whose real names and cover names have been restricted. Unlike Tranche 1, Phase 1, when the redacted witness statements of 2 fully anonymous SDS officers were disclosed, the open evidence of 7 fully anonymous SDS officers in Tranche 1, Phase 2 has been redacted to an 8-page group gist. We are told that some, but not all of these officers will be called later this year to give evidence in closed session. As others have observed, the group gist that has been disclosed is, in our opinion, unsatisfactory in many respects. It is so brief and thematic that it is difficult to glean anything meaningful from it as to the true nature and extent of the spying by the individual officers, or who precisely they each targeted and what precisely they each did during their deployments. We do not understand how the inquiry can suggest that a group gist like this enables the publication of more evidence than would otherwise be possible by divorcing the evidence from specific association with identifiable officers. The logic of this escapes us. We are being asked to accept that the more that is hidden from us, the more that we are being told. In any event, why change the approach adopted during Tranche 1, Phase 1 by introducing something even more restrictive? Was it to reduce the purported risk of mosaic identification? And if so, at whose behest? We trust that during future tranches and phases, the inquiry will revert to its earlier approach and disclose redacted witness statements from fully anonymous witness, as opposed to relying on another unsatisfactory group gist like this. Point number 5. What is immediately apparent from the disclosed witness statements of the SDS officers is that many, if not most, of their original intelligence reports are not in the hearing bundle. We had assumed that this was because the records of SDS reporting provided to the inquiry by the Metropolitan Police Service, were incomplete, as indicated in counsel to the inquiry's addendum disclosure note regarding Tranche 1, dated the 25th of March this year. However, the written opening statement of the designated lawyer officers group paints a different picture, alleging that it is the inquiry that is only releasing a small selective fraction of a fraction, as they put it, of the SDS intelligence reports that it has been provided. So what is the truth? Are the records of SDS reporting provided to the inquiry by the Metropolitan Police Service incomplete because these records have been destroyed and shredded over the years? Or is the inquiry withholding most of the SDS records that it has been provided, and hence so much is missing from the hearing bundle? Or is it both? We would welcome some clarification. Additionally, we are told that many of the SDS records that have survived and have been provided, labeled UCPI as opposed to MPS by the inquiry in the hearing bundle, are only in existence because copies had been retained by MI5. This suggests that not just the SDS, which shut down in 2008, but the Special Branch Registry itself has been getting rid of its files. That is worrying for obvious reasons. Interestingly, whilst MI5 is apparently happy to disclose copies of police documents, they are rather more circumspect in disclosing any of their own documents that might reveal the nature and extent of their own spying operations on political activists and others. Point number 6, redactions. What has been apparent ever since we started receiving disclosure from the inquiry last year is the sheer extent of documentary redaction, particularly on grounds of national security. Most frustrating, and we've raised this on several occasions already to no avail, is the redaction of the names of many groups spied on and infiltrated by the SDS between 1969 and 1984. These names should be as a matter of public record, surely. None of them should be redacted. How can it be justifiable for an inquiry into undercover policing to withhold the names of groups spied on and infiltrated by the secret state more than 35 years ago? In 2013, the government began to release its records to the National Archives that were at least 20 years old. So why can we not know all the names of the groups spied on and infiltrated by the SDS, at least up until the year 2000? What is the state hiding? What is the inquiry hiding? Surely the public interest in full and frank disclosure outweighs any other potential interest, given the inquiry can protect the right to privacy of any police spies by restricting disclosure of their real names. By hiding the names of some of the targeted groups, the inquiry is effectively preventing members and supporters of those groups from coming forward and telling their stories. What effect does this have on the confidence of non-state core participants and the public at large in the inquiry's work? In the SDS annual reports between 1969 and 1984, some 133 group names have been redacted. While some of the same groups undoubtedly feature on multiple occasions, there are, on any view, a huge number of groups who were spied on and infiltrated during this period, whose names are apparently to remain secret forever, at the insistence of the very organizations who were doing the spying and the infiltrating in the first place. This is madness. This is an abject failure of openness in the name of national security. The worst years were 1973, when the names of 19 groups have been redacted, and 1979, when the names of 24 groups have been redacted. Most of the redacted names appeared to belong to Maoist, anarchist, and Irish groups. However, there are others too, including Trotskyist, anti-fascist, and anti-nuclear groups. Such voluminous redaction is driving a coach and horses through the inquiry's primary objective of getting to the truth. We call for all these names to be unredacted, as it is in the public interest to know the names of all the groups who were spied on and infiltrated by the STS more than 35 years ago. There is simply no justification for such secrecy. Point number 7, sir, late disclosure. We appreciate that this has been raised over and over again by us and others, but I think it's important enough that it needs to be raised again. We are simply not being given enough time to read and digest the disclosed material before having to make opening statements and prepare for evidential hearings. We were supposed to receive the entirety of the current hearing bundle by the middle of March. On the 1st of April, over 1,000 pages of documents were added, and on the 9th of April, nearly 1,100 pages were added. We understand the difficulties. We are genuinely sympathetic. However, this is unfair to all core participants, but particularly to the non-state core participants, given the bulk of the material being disclosed consists of police documents never seen previously by the non-state core participants or their lawyers. We can only hope that this problem is not repeated in future tranches and phases. Turning then, sir, to Piers Corbyn. Back in 2015, when he was granted core participant status, he had no idea about the extent of the spying on him. Even in April last year, when he made his 79-page inquiry witness statement, he had only been provided with 53 special branch intelligence reports, most of which were relatively unrevealing, and no witness statements from any of the undercover police officers who had spied on him, still less any photographs of those officers to help him recollect events that took place between 40 and 50 years ago. Piers Corbyn's witness statement will become publicly available on the day he gives evidence. He would like to attend the inquiry venue in person to answer questions, but that has not been allowed because of the pandemic, and so he will give evidence virtually, video streamed and video recorded for posterity. Like most other non-state core participants, Mr. Corbyn has always been open and upfront about his politics and has nothing to hide. In contrast with the former undercover police officers who hide behind anonymity and object to their evidence being video streamed and video recorded. It has been said many times before, but bears repeating. An audio stream is a poor substitute, and the failure to keep video recordings is a disservice to the historical record. So why was Piers Corbyn of interest to Special Branch and MI5? It was over 50 years ago, in 1969, that a registry file was first opened on him, a file to which he has never had access and never will be given access. Mr. Corbyn was president of the Imperial College Union at the time. He was politically active. He attended rallies against the Vietnam War. In 1971, he joined the International Marxist Group and attended numerous meetings and demonstrations about the burning issues of the day, including Ireland, anti-fascism, anti-racism, and trade union struggles for better pay and conditions. In 1972, he was instrumental in setting up the Squatters Action Council and the London Squatters Union, and he played a key role in the victory of the Elgin Avenue squatters, all of whom were rehoused by the Greater London Council. Squatting was a response to the lack of affordable housing in London, especially for young people, but was also a way of trying to establish a new type of community in the form of communal living. In 1982, Piers left the IMG and joined the Labour Party, the year before his brother Jeremy was elected as a Member of Parliament for Islington North. In the 1980s, he was active in the Fair Fight campaign to keep down the cost of public transport. In 1986, he became a Labour councillor in Southwark for 4 years. What has Piers Corbyn learned from the current hearing bundle about the spying on him by the SDS that he did not know previously? Unfortunately, sir, almost nothing. Firstly, none of the 8 SDS officers due to give oral evidence mentioned Mr. Corbyn in their witness statements, although one of them, namely HN298, who used the cover name Michael Scott, mentions Mr. Corbyn in one intelligence report as having been present at a meeting about Ireland in 1974 that he attended. Secondly, the 2 SDS officers who do mention Mr. Corbyn in their witness statements, albeit only in passing, namely HN299342, who used the cover name Dave Hughes, and HN353, who used the cover name Gary Roberts, are not giving oral evidence. Their evidence is being summarized. Thirdly, although the inquiry gave Mr. Corbyn photographs to view from the 1970s of 3 SDS officers, none of these officers had spied on Mr. Corbyn. So unfortunately, this was a pointless exercise. By contrast, the inquiry has not given Mr. Corbyn photos to view from the 1970s of any of the SDS officers who actually did spy on him. In particular, the inquiry has not given Mr. Corbyn a photo to view from the 1970s of HN338, an SDS officer who attended 3 small political meetings at Mr. Corbyn's actual home in January, March, and June 1972. And we've provided the references of those intelligence reports in our written opening statement. HN338 is deceased. His real name is restricted, and his cover name is apparently not known. Fourthly, although Mr. Corbyn was granted co-participant status by the inquiry on the basis that he was one of the main organizers of squatting groups in London between 1972 and 1982, inexplicably, his squatting activism barely features in the intelligence reports in which Mr. Corbyn is named. In short, what has been revealed by the disclosure, unfortunately, is a damp squib. What would tell us far more about the secret state's interest in Piers Corbyn is obviously his registry file. And that's what Mr. Corbyn wants to see. But nobody ever gets to see their registry file, not even during a public inquiry into undercover policing. Unlike his friends in Germany, who were given access to their Stasi files in the 1990s after the collapse of communism in the former East Germany, Mr. Corbyn will sadly remain none the wiser about the full nature and extent of the British secret state's interest in him. Why will the British state not release Piers Corbyn's registry file, even after decades have passed, if only to Mr. Corbyn himself and no one else? Why is the inquiry unable to compel the state to do so, notwithstanding its broad powers? Is it because most spying is in fact so tedious and so routine and so unnecessary that any sensible citizen might question why so much taxpayers' money is being wasted? Or is the state afraid of something else? We will never know, because I'm afraid the inquiry is never truly going to be allowed to penetrate the edifice of secrecy at the heart of our surveillance society.
Sullivan, please contact the switchboard.
While While secrecy continues to trump openness, the inquiry will only scratch the surface. However interesting and revealing some of the redacted documents it is disclosing undoubtedly are. In conclusion, sir, there are 2 further points we wish to make in light of recent developments. Firstly, the Designated Lawyer Officers Group, in its written opening statement, expresses concern about what Tariq Ali said in evidence about the killing of Blair Peach, and Piers Corbyn said,
public court users are reminded to maintain social distancing and wear face coverings throughout the building and are encouraged to wash or sanitize hands frequently. Thank you for your cooperation.
I'll just repeat that sentence, sir. Firstly, the Designated Lawyers Officers Group, in its written opening statement, expresses concern about what Tariq Ali said in evidence about the killing of Blair Peach and Piers Corbyn said in his witness statements about the killing of Kevin Gately. The inquiry's function, it is submitted by the Designated Lawyers Officers Group, is to generate light, not heat, and that we should all guard against the making of inflammatory allegations, however emotive or sensitive the subject, however tragic what happened, however appalling the lack of police accountability. Let's go back to basics. Blair Peach was killed by a police officer. Mr. Ryder of Council said it yesterday, and I repeat it today. That is the truth. There is nothing inflammatory or contentious about saying that. On the contrary, to pretend otherwise, to describe the blow that killed Blair Peach without acknowledging that it was a police officer who struck that blow, makes a mockery of history, as does denying the subsequent cover-up by the police, the coroner, and the Home Office. As Tariq Ali told you in November, sir, when he gave evidence, he too was on the receiving end of police violence in Southall on the 23rd of April, 1979. He was hit on the head with a police truncheon and knocked unconscious. He described that as, and I quote, like a leaf taken out of colonial police manual in India during the days of the British Raj. As far as the events in Red Lion Square on the 15th of June, 1974 are concerned, whether you believe that Lord Scarman's exoneration of the police was just another establishment whitewash or not, there is nothing inflammatory or contentious about saying that Kevin Gately died from a head injury likely caused by a blunt, hard object. That was the pathological evidence. There is nothing inflammatory or contentious about saying that mounted police officers were striking at the heads of anti-fascist protesters in Red Lion Square with their truncheons. There are photographs in the public domain that show exactly that happening. And there were other protesters present in Red Lion Square with the injuries to prove it. Consequently, it is hardly surprising, you may think, sir, that many, including Piers Corbyn, believe that Kevin Gately was struck on the head with a police truncheon, as opposed to any of the less likely alternative explanations posited over the years. Finally, the latest delay of Tranche 1 Phase 3 until 2022 and Tranche 2 until 2023. As I'm sure you appreciate, sir, there is universal dismay and anger amongst the non-state core participants about this latest setback, which on any view plays straight into the hands of those who benefit from delay, namely those who want to preserve the secret state at all costs. It's obvious, the longer the delay, the longer that most non-state core participants will have to wait for disclosure, the more evidence that will be lost, the more witnesses who will die, the more witnesses who will become too ill to participate, the more difficult it will be for the inquiry, sir, to get to the truth. As one non-state core participant described it, this is yet another slap in the face. When are those who were spied on in the 1980s and subsequently going to receive disclosure? When is the inquiry going to finish? When is there going to be accountability? Is there a realistic plan, or is the inquiry being kicked into the long grass? We ask the inquiry to reconsider any further delay. Justice delayed is justice denied. Thank you.
Thank you, Mr. Menon. We're now going to have about an hour's break for lunch. Because you have finished a little earlier than you were allowed, for which I'm grateful, we will resume at 2:15, not 2:20. Thank you very much.
We shall now take an hour's break for lunch. Proceedings will resume at 2:15 p.m.